Thank you, Sally, for having me, and thank you, everyone else, for tuning in to discuss prescription benefits through a legal lens. And I'd like to preface the conversation just by saying that I am not a lawyer, and nor will I be giving legal advice today. My goal here, y'all don't want that, trust me. My goal is just to discuss some of the pharmacy benefit management practices that are taking over news headlines as of late. Between legislation, lawsuits, and lies, PBMs are getting far more than their 15 minutes of fame. Really, we just want to make sure that you and your clients stay out of those headlines. So, I just want to kick things off by discussing and giving a brief overview of a few timely and popular happenings. First, the Pharmacy Benefit Manager Transparency Act of 2023. In short, this bipartisan bill was approved last year to be sent on to the full Senate. And it's an act that would help lower drug costs and increase transparency for consumers by doing a few things. It would make spread pricing illegal, meaning that health plans could not be charged more for prescription drugs than what is being reimbursed to the pharmacy. It would prohibit clawbacks or those prescription drug overpayments that occur when a member's copayment exceeds the actual cost of the drug, and then the PBM pockets or claws back that difference. It would prohibit increased fees and lower pharmacy reimbursements, which PBMs may use to offset their reimbursements from federally funded health plans. Um, and then it would require PBMs to disclose the cost and reimbursement of drugs to the health plan, including any fees or discounts that they incur. And finally, it would require PBMs to pass through 100% of rebates to the plan sponsor, whose money it already belongs to. I'm pretty sure that all of those attributes are things that we would like to see in any PBM today. So hopefully the act goes through. However, I don't believe anything is scheduled on it. So it remains in legislative limbo for the time being. And last but not least, we have possibly the most popular news headline as of late, the J&J lawsuit. This class action lawsuit was filed by an employee of Johnson & Johnson, and it accuses the employer plan sponsor of breaching its fiduciary duties and mismanaging the plan's prescription drug benefits. That's it in a nutshell. The breach of fiduciary duty is alleged in several ways, and I have a few of those that are taken directly from the lawsuit. First, it alleged that J&J failed to complete a prudent PBM selection process. They agreed to make the plan and its beneficiaries pay unreasonable prices for prescription drugs. They agreed to contract terms with its PBM that needlessly allows the PBM to enrich itself at the expense of the company's plan and its beneficiaries. The plan sponsor failed to actively manage and oversee key aspects of the company's prescription drug program, and they failed to take available steps to rein in its PBM's profiteering and protect plan assets and beneficiaries' interests. If y'all haven't read through that lawsuit, I encourage you to do so. It is a pretty easy read for a lawsuit, and I would almost say enjoyable to read if it weren't so alarming and just sad. It really brings light to some of the most devious and terrible PBM practices out there. And it really, rightfully should raise questions and concerns among plan sponsors and even broker and advisors alike. Uh, but my point in reviewing some of these hot news headlines is just to showcase a common theme. And that's the need for truth and transparency in the prescription benefit marketplace. Y'all, we cannot wait for that to be mandated, though. Legislative advances could be years down the road, but the next lawsuit could be just days away. Anyone can file a lawsuit for a couple $100. But the beauty is we don't have to wait. The more you know now, the better solutions you can put in place now. So I want to just dive into some of those marketing buzzwords that PBMs love to use so much. And all the transparency and fiduciary frill in the world means nothing without definition and verifiable commitment. So, fiduciary in a nutshell really just means loyalty and prudence. Loyalty by way of legal obligation to act in the best interest of another rather than oneself, and prudence by maintaining responsibility to use care, caution, and good judgment in handling affairs for others. While I definitely think that it is important for PBMs to act in a fiduciary manner, it is so important to note that they do not hold legal fiduciary duty. And in light of this lawsuit, you're going to see a lot of PBMs touting fiduciary status in marketing materials or messaging. But as the J&J lawsuit points out, the fiduciary to the plan is the plan sponsor, not the PBM. I think the verdict is still out on where the advisor sits in terms of fiduciary acts for the plan. But in short, PBMs who claim to be a fiduciary of the plan, however, by serving in an administrative role rather than truly exercising discretionary authority over the plan, PBMs have been ruled to not be fiduciaries under ERISA, and therefore they have no legal responsibility to act as such. That is big. That means, when push comes to shove, they would hold no legal responsibility. There was an instance not too long ago. The Massachusetts Laborers Health and Welfare Fund had sued Blue Cross Blue Shield, a TPA, for breach of fiduciary duty. However, the courts ruled that Blue Cross was not exercising discretionary authority or control over the plan, and therefore they were not a fiduciary. The courts did note, however, that Blue Cross had failed to follow their contractual obligations. So it's really important to draw and define that line there and understand what true duties the PBM or TPA or any third party administrator might have for the plan. So in knowing that claims of fiduciary status don't bear much weight, if or when push comes to shove, TrueScripts has instead contractually obligated ourselves to transparency. And trust me, we dislike the word transparency just as much as the next person. It's been overused and overpromised, underdelivered on. But our contract our pharmacy services agreement actually contains an affirmative covenants and transparency commitments clause, which again contractually obligates us to operate in a fully disclosed and mission aligned manner for our clients. We have clearly defined our commitments so that any deviance from those responsibilities can be identified and reproved. So basically, you are able to trust and verify that what we are saying and what we are promising you to be true, which in a sense, going back to the definition of fiduciary, trust. And so we're really putting action to these words. I want to dive in a little more to the transparency part of things. It's no longer enough just to claim transparency based on your ability to, the PBM's ability to pass through rebates or pricing. There is so much more to it than just that. And even claiming to be passed through on rebates, there's ways that they can manipulate that. I think it's very important to know the revenue sources of your PBM. There are 50 plus ways PBMs can generate revenue through hidden practices or manipulation of processes and responsibilities that they own, where they can generate revenue through. A very low or even a $0 admin fee should be a red flag. No one is working for free, and they shouldn't. But if there's no admin fee, where else is the money coming from? It's being pulled from somewhere. And if you don't know where it's being pulled from, you can't possibly know how much is being taken. So it's very important that there are clearly defined admin fees, being the only way that money is made. And I think true transparency also translates to auditability. So we provide clients with complete insight to invoicing so that everyone can understand what they are paying for and how much. Access to data is another big one. Informed decisions can only be made when you have all the facts. Plus, for any plan, self-funded plan sponsor, it's their data. It should be easy to access and understand. Um, let's talk about the contract. So I've seen some contracts upwards of 50 pages. We like to joke that those 50 pages, maybe the first 25 are the PBM making promises, and the next 25 them intricately undoing those promises. And many times the contract could be so long that even if you were to take the time to read through everything, you would find that the PBM was transparent in telling you that they are engaging in spread pricing or rebate retention. So, TrueScripts, we have a 9-page contract. It is straightforward, easy to understand. And I think that plays a big part in transparency. The next one is a big one for us, and a big one if you read through the J&J lawsuit. An issue referenced several times in the J&J lawsuit is pharmacy ownership, the ownership of pharmacies by PBMs. And to paraphrase the lawsuit, when a PBM owns a pharmacy, there are foreseeable ways in which it would attempt to enrich itself and its own pharmacy at the plan's expense. Y'all, that is a huge conflict of interest. And that conflict of interest can compromise everything from a PBM's objectivity in choosing the most cost-effective and clinically appropriate drugs, or it could hinder patient access to care by steering patients to those cell phone pharmacies. TrueScripts founders recognized this conflict of interest long ago, and we have vowed not to own pharmacies of any kind. On that same note, I think it's important that we discuss ownership of the PBM itself. Who owns your PBM? The top 3 PBMs are all part of companies that own healthcare insurance companies. So that vertical integration in of itself can lead to conflicts of interest and also a lack of competition, which has negative impacts on patients and plan sponsors alike. Additionally, I think PBMs receiving outside investment in the form of PE or VC funding, any entity receiving, and I don't want to just pick on PBMs here. There are some good PBMs out there, but it changes things. They could have a different objective. They now have a need to maximize return for investors rather than acting in the best interest of the plan and its members. We are extremely fortunate here at TrueScripts to now we're independently held up until this year, and now we are a team member owned organization, or ESOP. So we are not beholden to any outside shareholders. Our team just has a vested interest in the success and happiness of our clients rather than investors. So again, I say all of this. While the thought of having a transparent or fiduciary PBM is great, those claims to fame must be identified, defined, and verified, or else all you have are some flashy words with no backbone and potentially a long list of vulnerabilities for the client, the members, and maybe even the broker advisors. we understand that these lawsuits and legislative proposals and just all of the industry happenings create feelings of fear and uncertainty and hope even. And while it is ever evolving and we might not always have the answers right then, we, myself, my team at TrueScripts, we are always open to working with you to find those answers, to provide support and education when and where we can. Our team, we have an incredible team. We have nurses, pharmacists, legal experts, data scientists, just SMEs of all kinds, and they're all so willing to help. And I truly mean that, guys. We are not in this just to build sales for TrueScripts. We want to build an industry of knowledgeable purchasers so that together we can all build a better future for healthcare and prescription benefits. So I hope this overview of everything is helpful and provides some peace of mind that you don't need to wait for legislative advances to come through and for the government to step in. There are good PBMs out there doing the right thing right now. And it's not just us here at TrueScripts, there are others, but it's all about digging in. You got to kick the tires, check under the hood. Ultimately for plan sponsors now, it's unfortunate that this is happening with J&J, although they've put themselves in this situation, but y'all are the responsible fiduciaries. And so we want to help you act in a fiduciary manner, but it's also really important to understand the legal aspects of that and what your PBM or any plan vendor can and should be doing to help and protect you and your members from all these crazy outside forces.